hari ini kita datang ke Mahkamah Rayuan, ada dua bahagian yang hendak diperjuangkan. Bahagian pertama, sama ada Mahkamah Rayuan membenarkan keluarga kita meluluskan permohonan keluarga kita untuk memohon rayuan. Kerana kalau Teoh Beng Hock mau teruskan rayuan, harus dapat persetujuan dari Mahkamah Rayuan. Tadi Mahkamah Rayuan telah memutuskan untuk memberi permohonan kita untuk rayuan dibenarkan.
Tari meneruskan. Belum lagi kan?
Masih akan teruskan nanti. Ya.
Jadi puas hati tak dengan keputusan Mahkamah ini?
Pada peringkat ini apa yang kita harap sebelum keputusan keluar, kita harap kita ada satu peluang untuk membuat rayuan.
Untuk keadilan.
Ya, itu adalah satu permulaan untuk menuntut keadilan untuk Beng Hock. Tapi lepas ni kita akan kita harap ada satu persidangan terbuka kepada semua orang agar dapat ambil tahu semua perkara yang berlaku dalam Mahkamah Rayuan.
Sidang media. Saya lagi ada satu sidang media.
Ada hearing. We hope that there will be a hearing for us before the decision. We hope that because in High Court we didn't have any chance to hear any hearing. They just make decisions straightforward. So we hope that we can have a hearing.
This was an application for leave to appeal against the decision of the High Court in Shah Alam, where the High Court judge acting in revision had dismissed our application to set aside the finding of an open verdict in the Magistrates Court, the Coroner's Court, and substitute it with a finding of homicide. So we went to the Coroner's Court. Coroner came back with an open verdict. Then we went to the High Court, asked the High Court judge to convert it to one of homicide. He dismissed that application, so now we have come to the Court of Appeal. The procedure under the rules is that we must get leave. So today is an application for leave to appeal against that decision, and the Court of Appeal has granted us leave to file an appeal against that decision, and we have 14 days to file the notice of appeal from today. So now what we have to do is file the notice of appeal and then come back here when the date is fixed by this court to argue the appeal proper. And I think, as you are aware, the argument that we took up today was one which related to standard of proof, whether or not the learned coroner and the High Court judge applied the correct test required of them in coming to a finding that it was an open verdict. What happened was both the coroner and the High Court judge ruled that although there were strong facts which showed suspicion of homicide, they were of the view that the law did not allow for a finding to be made based on suspicion alone. That is the question that we have raised before the court today, and the court has agreed with us that it is a point to be argued. Whether we will succeed or not, I'm not sure, but we will come back when the appeal is filed. Notice of appeal, yes. Ordinarily, you will find that we appeal, like for example, when the case is heard in the High Court, we appeal in a criminal trial, you appeal straight to the Court of Appeal. If you're unsuccessful, you appeal straight to the Federal Court. But in some cases, the law requires that you need to get leave before you can appeal. So what happens there is that you file an application for leave. If the application is granted, then the court will direct you to file a notice of appeal within a certain specified period of time, and then after that it operates like a normal procedure. Yes, so today that was the application. The court has agreed with us, granted us the leave, and directed us to file the notice of appeal within 14 days, and I hope to file it by tomorrow.
The judge said they are satisfied that the A and B, what what is that?
No, that's technical. That's in respect of my. That's the prayers that they are allowing, giving us leave to appeal and 14 days to file a notice of appeal.
Okay.
But I think the crux of the matter revolves around the standard of proof applied by the coroner and the High Court judge, whether or not in an inquest the coroner is bound to follow the normal rules of procedure, which means that whether the coroner is only allowed to make findings based on facts proven beyond reasonable doubt, or whether or not in an inquest a magistrate has got more latitude where a decision can be made on probabilities as well. So that's the question of law raised today. Okay?
But on the family side, we want the decision to be made based on the facts.
Yes, of course. You see, it's a determination of the question of law. Upon determining the question of law, then we apply the facts. So here, of course, if the court finds that the coroner and the learned judge had misdirected themselves in respect of the standard, then they would have to reconsider the case, applying the correct standard. So we go into it again. So, but of course, that is subsequent to decision on the question of law itself.
If the court, when hear the appeals rule in favour of you, that means the coroner decision is overturned, is it?
Yeah, no, we are asking for it to be set aside and substituted with a verdict of homicide.
So they won't go back to the
No.
Shah Alam High Court to hear the...
No.
So that means they will hear the review, is it? The appeal is to hear the review.
Yes.
So the family stand is that you want the court to...
We are pushing for homicide. We are pushing for homicide.
I mean the latitude, I mean the standard of... Are you going for the facts or going...
Both. I mean, before... In order to apply the facts, you need to know what the law is.
Okay.
Otherwise, you do not know what you are applying the facts to. So if the standard that was used by the High Court judge and the learned coroner was the higher standard, then of course the arguments that we have put forward, which ought to have been accepted, were wrongly refused or rejected. So that's why we are asking this court to determine what the standard is. So if the court agrees with us that in an inquest, you do not have to meet the actual standard of proof in a criminal trial, which is beyond reasonable doubt, it's actually the lower standard, then we will be pushing and we will be saying that on application of facts to that decision in law, then we have established a case of homicide. Whether or not they agree is also again a separate matter. But that is what we are pushing for.
So if the court rules that the case be just based on the facts, so the homicide is established.
Well, they have to then ask themselves whether or not the facts as they stand establish homicide. So it's a two test. One, standard of proof. The other, on the facts, whether or not there is homicide.
Okay.
So it's not automatic. We still have to argue.